Is technology a game changer for human rights in corporate value chains? This panel is going to explore the complexity of the relationship between business interests and digital marketing models on the one hand, and individual human rights on the other. A difficult balance to strike, that is. It's a crucial relationship that's often overlooked or insufficiently implemented or adhered to. We've got the advisor at the United Nations Human Rights Committee, Isabel Ebert, Professor at the Oxford Department of International Development, Ivan Manokha, and Joshua Meltzer, and they're going to discuss the frameworks around human rights in business and technology.
Welcome to the World Ethical Data Forum for a discussion today on human rights in business and technology. My name is Joshua Meltzer. I'm a senior fellow at the Brookings Institution in Washington, D.C., where I work on a range of technology policy and legal issues. It's my pleasure to have here today Dr. Isabel Ebert and Ivan Manokha. I'll introduce them briefly, then we will go into short presentations and have a moderated discussion amongst the group. Isabel Ebert is an advisor to the BTEC project at UN Human Rights on Business and Human Rights in the Technology Sector. She's also a senior research fellow at the Institute for Business Ethics at the University of St. Gallen and holds a PhD in organizational studies. Ivan Manokha is a departmental lecturer in international political economy at the Oxford Department of International Development, and in his recent research he has investigated the implications of new technologies of surveillance for different individual rights. Their full bios can be found on the World Ethical Data Forum. Let's start with you, Isabel. I'll turn over to you for a short presentation. Thanks.
Yeah, thanks, Joshua. I'm here today to talk about sort of the norm shift that we've been seeing, how also globally the private sector has come more into the association with specific human rights impacts. I would like here to mention the UN Guiding Principles on Business and Human Rights that have been endorsed by the Human Rights Council about 10 years ago. They are actually cross-sectoral in their character, but the BTEC project that I'm representing here today has set to its aim to really operationalize those UN Guiding Principles for the technology sector and break them further down and make them useful to understand better how also technology companies have the responsibility to respect human rights. Just to also set out clearly that while the UN Guiding Principles set that specific focus also on the responsibility of companies to respect human rights, they still conceptualize the state as the primary duty bearer to protect human rights, which is conceptualized under Pillar 1 of the Guiding Principles. And then what the UN Guiding Principles add is that specific Pillar 2 that conceptualize the corporate responsibility to respect human rights in conjunction with Pillar 3, discussing the necessity for the state, but also particularly business, through operational grievance mechanisms to provide potential victims of human rights abuses with the access to remedy. But I think while I'm mentioning the UNGPs here is that they are really one of these important and also universally agreed framework stemming from the human rights thinking, and the UNGPs can really serve as a roadmap to conceptualize also the responsibilities of tech companies when it comes to human rights. We've been seeing there's also a lot of discourse around AI ethics, which is not the topic of today's debate, but again here, while this is sometimes perceived as a sort of as a contradiction between each other, between ethics and human rights, I think we are really believing that human rights can be the bedrock and can, to a certain extent, be also complementary to some of the debates going on around fairness, accountability, transparency, and AI ethics. our project has 4 focus areas along the thinking of the UN Guiding Principles. We analyze human rights risks that are associated with business models of technology companies, but we look also into tech companies, really trying to understand what processes technology companies need to better understand how their daily business decisions can put human rights at risks, and how they can really identify, mitigate, and address the risks stemming from their use of digital technologies or the products and services they're offering with the help of digital technologies. And adding to these 2 work streams on business models and the managerial processes, in particular human rights due diligence. We are also looking at what I've mentioned earlier, access to remedy, and particularly here also operational grievance mechanisms, where you see that some tech companies have come up with solutions how they can get into in touch with affected user groups, but also affected stakeholders that are not maybe actually users of their services. And last but not least, we're also looking at the options that states have at hand in order to require businesses to respect human rights. Might that be through regulation or also through voluntary incentive systems or state financing, procurement practices, providing specific guidance for tech companies that are operating in high-risk business environment and so forth. Yeah, so the project started to really kick off last year after a stakeholder consultation process, and now we've just published a range of foundational papers that you can find on our website. And those we will now be sort of going out to stakeholders and try to bring life to these papers. And yeah, really looking forward to the conversation today. I think Ivan will kick us off also with some of the more particular challenges he's been observing from his academic research. Thank you very much.
Thank you. Over to you, Ivan.
Right. Well, thanks a lot. Yeah. I think, as Isabel said, these UN guidelines, obviously, they offer a very important roadmap, as she said, for different state and non-state actors on how best to approach the question of regulation and self-regulation to make sure that enterprises comply with human rights, on how best to promote and protect human rights. But I think it is also important to realize that business firms, especially business firms which collect personal data, process it, to come up with ever more nuanced and profiles, and to make inferences about individual personalities, tastes, preferences, and so on and so forth, and which then monetize this information. They generate astronomical profits, huge profits. And I think, well, it's difficult to estimate the size of gains that they make, in particular from targeted advertising or micro advertising, in the case of platforms such as Facebook or different data companies, data suppliers, or data brokers. But available figures at least show the scale, the extent. And one estimate puts yearly earnings of Facebook from targeted advertising in 2018 to over $35 billion US, which represents over 60% of Facebook's earnings. And in the study, in the most recent study by the European Commission in 2020, they estimated that in 2019 there were about close to 300 data companies operating in the EU plus the UK, and they generated revenue close to $100 billion US, about 85 billion euros. So I think it is important to bear in mind when we talk about attempts to regulate these companies that the business model, as Isabel said, the business model that they use is de facto based on surveillance and constant privacy invasion, on permanent, incessant information gathering with respect to different users and their activity. Or even directly from the devices that they use, material objects that they use that are connected, and then processing, sorting of this information to develop different products, profiles, and then sell. this information for profit, just like traditional industries require raw materials, obviously, to generate revenue. These companies require user data and personal data to make these astronomical profits. So I think in this respect, what we can say is that data has become a commodity, and I think we may use the term fictitious commodity, which was used by a Hungarian historian, Karl Polanyi. He used the term to refer to things like human labor or land or nature, because these are fictitious commodities, according to him, because they are not intended for sale, they're not produced for sale, and if you treat them as such, there are risks to destroy the environment or the society. And I think it is possible to develop this kind of argument with respect to privacy. The data that is collected by users, it's not produced for sale. People engage in activities that they engage in. They do what they do. But these enterprises, they capture this data, they gather it, and modify, and commodify this, and with obvious implications for privacy. Now, there are implications for human dignity, of course, which have already been discussed quite a lot. But I think there are also implications for other rights, for other individual rights and liberties, for which privacy is very important. Obviously, it's hard to exercise rights such as the right to vote, or to organize, to create political parties or movements, to organize trade unions without privacy. And so I think this fictitious commodity may in the sense of treating data as commodity in this way might have very serious implications for democracy and democratic politics itself. So I think on the one hand, it's clear that there is an urgent need to regulate this sector, but at the same time, it's also important to understand that for these firms to generate these massive amounts of profit, they have to engage in this constant surveillance and privacy invasion. It is a structural imperative for them. It's a kind of it's DNA. It's DNA of this form of capital, which means, given the stakes that are involved, that it will certainly not be easy, and they are likely to resist and mobilize extensive resources that they have at their disposal to fight any attempts at regulation which might endanger this business model. Yeah.
Great, thank you. I think we've got a lot to go on here. Why don't we actually start with privacy, I guess, Ivan, because you've spoken a lot about that, and not only as an important right in and of itself, but I think in some respects as enabling other rights, certainly when it comes to sort of democratic participation and functioning. Isabel, let me just ask you, can you elaborate a bit more on how, whether it's the right to privacy or broader rights that are important from a democratic perspective, how that's reflected in some of the UN rights that you are, engaged with, and what you see, I guess, more specifically as some of the core sort of challenges in terms of translating these rights into actual business practices?
Yeah,
I think it is. This is the key question. Well, we may start by observing that the UN documents which embody different rights, they were created in the world before the rise of all these digital technologies, before machine learning and artificial intelligence. They were created, so to speak, for offline world. But now, with the arrival of these technologies, I think it's clear that enhanced surveillance is rendered possible, and different state actors and non-state actors, as well as individuals, may engage in different kinds of data gathering and processing for different needs, and this may have implications for human rights, broadly speaking. Like I said, it may clearly endanger privacy, because, as I said, the business model is based on this constant need to invade individual privacy. But not only, I think, when you speak, for example, about the way this data is used, for instance, with respect to targeted advertising, this may also have implications for such for rights such as freedom of speech, for example, freedom of expression, because freedom of expression is not only about saying things, but also having access to information. And a lot of information today that people get, they get on their newsfeed, you know, on their social media, and this is targeted, this is curated, tailored to their taste. And these algorithms, the formula that they use is well known. If you are like X, you will then like or enjoy reading Y. And so they get information, news that they are likely to appreciate, which, as we know, leads to the creation of different filter bubbles, and this has implications for public debate, for tolerance of other people's point of view. And we know that a lot of people who, you know, are constantly fed the same kind of information, they're no longer used to alternative points of view, and debates then often turn to violence. You may also have implications for labor rights, because a lot of surveillance technology and data gathering is used in the workplace, you know, movement tracking, key logging, different wearable devices that are used on employees. It also has implications for migrants, obviously, now with the, you know, securitization of borders and increased surveillance of borders, discrimination, gender issues as well, and so on. So I think there are very many rights that are at stake here. But in my sort of opening remarks, I wanted to show that there's also a link between some rights. For example, privacy. It is an important right in itself, but it also has important implications for the ability.
Let me just pause you there for one moment, because I think you're entering into a very interesting area that I want to bring Isabel in on briefly as well.
I'm finishing.
Yeah, Isabel, let me refer back to you. The original question was around picking up on Ivan's points about privacy and how that's being reflected in the UN human rights, and whether it's specifically on privacy or around democratic participation, and how you're seeing that playing out in the tech space at the moment.
Yeah, I think what Ivan has been touching upon a little bit already. I think in the public domain, in the beginning, we had this perception that in particular privacy and freedom of expression are the focus. And I think also partly related to the very important and also very high quality work done by the special rapporteurs, in particular in that areas, naming here also David Kay. But I think, so our project, I mean, of course, this is an important point of departure, but our project also conceptualizes, for example, privacy as an underpinning right. So privacy in particular in the data-driven economy, obviously being the sort of gateway to protecting other rights on which we might see adverse impacts when the data is collected and processed, that then allows for specific inferences, as Ivan, I think, called it. I think at the same time we have seen that the human rights framework is fit for purpose, also still being developed before the internet, certainly. But we have seen jurisprudence, for example, coming out of the European Court of Human Rights on workplace surveillance and the right to privacy, where you have seen that the judgments show that actually we can deal with some of the emerging issues through the human rights framework. At the same time, I think what we're really facing is a very fragmented policy landscape, also in particular driven by very polarized interest, how internet governance should be designed in practice. And that obviously has a lot of repercussions on the policy coherence when it comes to human rights protection in the internet space. At the same time, we really don't draw that line between like a sort of physical space and digital space, because it's really we're beyond that certain point in time where we can speak about rights in cyberspace and rights in sort of the real world. In that regard, we're really one major asset of the BTEC project is that we are really working very closely with academics and civil society, businesses, and all relevant stakeholders, such as also national human rights institutions, to better understand what are the concrete impacts and how they can be addressed and mitigated. And for that purpose, we also look specifically on also the management practices, what the tech companies put in place in order to deal with the adverse human rights impacts. And one of the principles that could lead that conversation is, of course, data minimalism rather than data maximization, but that's something that we will have to determine in conjunction with our stakeholders. At the same time, we were talking about the potential human rights that can be affected, and under the whole business and human rights perspective, what usually comes out of human rights due diligence analysis is that you have to act on those rights first that are the salient human rights risks and impacts, right? That you make an analysis and see where is really, from a saliency perspective, that area where I really need to become active as a corporate decision maker, for example. And I think I want to really highlight that as one important area where, at the same time, we also need to break information silos across institutions. And I'm not talking about breaking data silos, but really information silos about decision-making processes, so that the people who make the decisions affecting human rights on the grounds, and in particular in potentially cultural or regional areas where harms can be quite grave, that the people making these decisions really have the information that they need to make an informed decision, because that's really at the moment an issue. And it is also to be seen in the light of some of the business models being quite universalistic in their rollout globally. And if that isn't matched with really hands-on, practice-oriented information from the ground, it's really hard to find solutions. So we're aiming at closing that gap between impacts on the ground and the information that reaches the headquarters of the companies that are making such decisions in the tech space. Yeah.
One of the ways you sort of describe the BTEC work, at least, is what seems, from where I sit, to be multi-stakeholder type of engagement, which, as we know, is the more common form of sort of internet governance, at least, that countries in the West prefer, and involving governments, but also civil society, academics, as well as industry. But you did mention that under Pillar 1, the human rights framework is very state orientated. How do you see, is there a tension there? How does that actually, in terms of the way that you are engaging on this issue, but the way that the actual sort of legal framework applies solely to the operation of states? And is there, how are you trying to manage that tension, if at all? And specifically, both to both of you, we've spoken a lot about privacy, and I want us to be clear. Is privacy from where? And I think, Ivan, you're clear on this, and I just want to make sure this is also where you are, Isabel, in terms of what are the most salient human rights issues raised by technology issues. Is privacy and its implications for democracy the most important ones when you think about the intersection between technology and human rights, or are there others we should also be focusing on? Isabel, why don't you start, and then Ivan can pick up on that.
Right. Okay. Well, I mean, I have to say, when you put me on the spot on which rights sort of are important, I mean, for us, they're all equal. There are some, as I said, there's some work done in specific areas that has shown that certain rights can be gatekeepers and sort of, or gateway functioning rights, and underpinning some rights. But from this business and human rights perspective, it really boils down to the specific business case, the specific situation in which the company is placed and in which it has to make that decision. And if in particularly here now with the COVID experience, we have seen that out of a sudden, the right to health came obviously much more into the public spotlight than it had been usually when associated with technologies, because it was partly also in some society sort of taboo to start tracking health data, right? And there we've seen that in the light of the COVID experience, the public understanding has shifted. What is legitimate and what is not, and that obviously will have repercussions again then on privacy and so forth. So it's really that it's hard to isolate one right from another, because at the same time they are sort of all equal and shouldn't be sort of standing in competition to each other. So that's what I would say with regard to that, but happy to hear how Ivan would conceptualize it.
Yeah, I think, of course, there are certain rights that we can identify, as I mentioned, privacy or labor rights or rights of migrants. But I think we might sort of extend this to freedom from discrimination in very broad terms, because there are algorithms that may perpetuate, even amplify existing biases, prejudices, stereotypes, and maybe entrench different inequalities. You know, it's enough to go to Google Images and do some searches. You can search, for example, for babysitter or nurse, and you will get pictures of women. And if you search for top manager, you'll get, you know, mid-aged white men usually. So another dimension which I think illustrates this really well is the increasing use of algorithms in law enforcement and criminal justice, things like predictive policing, which is based on past historical data to predict the occurrence of crimes. And as many analysts have shown, that this raises a whole range of ethical issues about enforcement and about where exactly do you dispatch patrols, what kind of areas are policed more than others, and historical data is not a very, it's not a very good guide for making these decisions, because this data is based on past decisions about where to send police patrols and on over policing on certain areas, and more arrests being made in certain places than others, and also past data may simply be unreliable, and so these are different concerns that I think emerge when we speak about data gathering and the development of these algorithms in more general terms. Discrimination, it can be based on ethnicity or race or gender, as well as important individual rights, freedom of expression, privacy, the right to organize, and so on and so forth.
Thanks, Ivan. That's very helpful. And I think one of the issues we are not getting into today, but we've skirted around, and I just want to draw the link out a little bit more, which is sort of throughout your comments, Ivan, is you talk about algorithms and discrimination and fairness, and we're really sort of moving quite firmly into the world of AI ethics. And Isabel, you sort of drew a distinction between human rights and AI ethics, and I think suggested that sort of the human rights framework provides a foundation for thinking about AI ethics. I may have misunderstood you there, but do you want to just articulate a bit further how you see the AI ethic debate layering onto the human rights framework, and where it works and where it doesn't?
Sure. I mean, I think the area of discrimination is actually quite interesting, because you have provisions that you can more answer from, like a fairness, transparency, and accountability debate that might then perhaps more go more into details around like data models and whether certain groups are fairly represented or not, and how such biased representation can be corrected and so forth. That's more like a debate about quantitative social science / statistics. But at the same time, if you have access to that information, and it's, let's say, something that is used in a hiring algorithm and produces adverse results, then that's a business decision, that's a business process, and that's where human rights due diligence and the whole business and human rights approach stemming from the UN Guided Principles on Business and Human Rights, that's where the human rights framework would have a lot to say about. You shouldn't be obviously having adverse impacts on the right to freedom from discrimination, right? So that example, I think, can show us how the more sort of statistical, quantitative social science debate leads into raising human rights questions. At the same time, I think what the human rights framework provides is really saying this is the minimum common denominator. We won't go below that line. And I think some discussions that you can, I mean, we would have to come up with a definition of AI ethics first, but some discussion that you can see in AI ethics is also about, let's say, how to raise the bar from the minimum standard, right, to positively impact certain things. And at the same time, human rights would say, right, you try to achieve a positive impact here, but only if you can guarantee that this minimum baseline is really upheld. So I think that's sort of the connection there. And when we put that onto the backdrop of the sort of regulatory efforts that are ongoing, we're really moving from the question of whether we should have regulation of tech conduct at all to the question, how is it actually effective? What makes sense? How are we really protecting people from harm rather than is that actually necessary? And I think that's also the appropriate debate to have, right? Where also the business and human rights approach can offer certain experiences and also draw from best practices that we've seen in other sectors that have a similar agglomerated power structure.
Yeah, and I also think, just to add one more point on algorithms, and I think this speaks to the earlier point made by Isabel about decision making. A lot of these algorithms that are used, for example, again, to go back to the issue of predictive policing, such as predpol, or in criminal justice to make decisions on bail and parole, such as Compass or Northpoint, these algorithms are really black boxes. We don't know how they operate, and they are considered proprietary secrets, really. So this is a very important issue as well to deal with.
Great. Let me ask a final question. One of the I tend to find that when we talk about whether it's on an AI ethical issue or the human rights and technology, we get very focused on what tends to be happening, particularly on the large platforms that the United States tends to dominate, but obviously China's a very big player in the tech space as well. Other countries are going digital in various ways. So if we cast our eyes outside of Europe and the United States and look more broadly at the world, what do you see looking forward as some of the emerging sort of tech and human rights issues around the globe? Isabel, if you want to sort of start and finish with that, and Ivan, if you've got any final comments.
Yeah, I think what's great to see is that the debate starts becoming more nuanced, also with regard to how to, let's say, ensure diversity of the voices involved, make sure that people are present in certain advisory boards or whatsoever that really can show the whole diversity from regions. So I see that important organizations such as the Global Network Initiative are really now being more successful about sort of ensuring that a diversity of voices in their membership, from not only from corporate members, but also from civil society and academic members. And only through that can you really understand how some of the North American, but also perhaps Asian models are really impacting people also in Latin America or Africa. And I guess without having such voices present in these conversations, you cannot really create good policies, right? May that be policies on the state level or on the multilateral level. I would to also here highlight the work done by the Freedom Online Coalition, obviously, right, where you see that really important effort being made by various state actors to ensure that internet governance can be a little bit more coherent by several states sort of trying to come to the same position on specific asks. For example, on human rights and artificial intelligence, there were several statements that were quite helpful to sort of level the playing field a little bit. But I think that's really what we need at the moment to close this governance gap between different perceptions, how human rights issues should be dealt with on a more sort of global scale.
Great, thanks. Ivan, any final comments?
Yeah, I think there are obviously very many promising developments in science. In the civil society, of course, you have different important NGOs such as Privacy International and Electronic Frontier Foundation. You also have at the regional and state level different initiatives, and most notably, of course, GDPR in Europe. At the same time, just to add a kind of a grain of salt, I think a lot of these efforts often, I assume implicitly or explicitly, as it is the case with GDPR, that once individuals have given their informed consent, as it is called, the data collection and sharing with third parties is legal. It's allowed. At the same time, I think, as we know, this assumes that individuals have read the terms and conditions of all the services that they access, and that they have understood this. And numerous studies show that only a tiny percentage of people actually read these terms and conditions. Very often they are designed in such a way that that individuals are nudged towards accepting them without reading. Sometimes it is very complex and a certain level of education is required. And I think more generally, just to conclude, this kind of approach puts a lot of responsibility for data protection on individuals. Okay, privacy is an individual right, but it doesn't mean that individuals are responsible or exclusively responsible for protection of individual privacy. And this kind of design or kind of offloads responsibility onto individuals who do not really have the resources and capacity and maybe cognitive effort to spare to understand all these complexities. So there is this issue as well that needs to be addressed in my view.
Great. Thanks, Ivan. I think we've had a very rich conversation. I want to thank both of you for your presentations and for engaging so fully with these questions. Look forward to seeing you in another event.
Okay.